All right, Mr. Burbank, Mr. Malfino, and sir, again, you're Brandon Bell. And so, well, just to get us back where we need to be, everybody's reviewed pre-sentence report, made argument. I want to go back just one more time and see. I know, Mr. Burbank, you're asking that I continue Mr. Bell on probation. Ms. With treatment. I know Ms. Lopez has made her position very clear. Ms. Malfino, what is the state's position?
Welcome back to the channel. And today, we're stepping into a courtroom moment that is as dramatic as it is intense. This case revolves around Brandon Bell, a defendant whose history of violent offenses, probation violations, and repeated criminal behavior has brought him back before the court yet again. What makes this hearing so compelling is the tension between those who still believe Brandon deserves another chance at treatment and rehabilitation, and those who insist the time for second, third, and even fourth chances is over. Prosecutors, defense attorneys, and even those who have worked directly with him are here to give emotional and blunt testimony about his past actions, the impact on his children, and how synthetic drugs may have contributed to his mental decline and violent conduct. As we move through this breakdown, we're going to analyze what's happening in real legal terms. What does it mean to violate probation repeatedly? What authority does the judge have today? And why is synthetic marijuana such a recurring concern in Texas courtrooms? But beyond the legal side, we'll also explore the emotional weight of a case involving children, domestic violence, and a pattern that has stretched back to Brandon's juvenile years. Stick with us to hear how the state argues he's too dangerous to stay free, how the defense pushes for another chance, and how the judge ultimately arrives at a sentence that is stronger than some expected. Let's get into it.
Judge, I certainly have ultimate respect for Ms. Lopez's position. She knows the defendant and what she's been dealing with a lot better, probably has a slightly different perspective on the kid other than what I do, so I certainly defer to her opinion. I also at the same time agree that probably the safety special needs to address that synthetic marijuana issue may be relevant. Has he had that opportunity in the past with some other charges? Yes, very well so.
So what?
Revocation may be appropriate, Judge, based on the underlying offense itself. If it is not, of course, we would be of the opinion that if he goes to that and violates zero tolerance in any way, shape, or form, we ask for that.
Okay, I'm just reminding myself also, so what I did not do previously was go through and take a look at that old pre-sentence report, which has the criminal history, which includes
Several sentences in prison.
Already been to prison, given an opportunity on probation in 2020, which is not long ago, 5 years ago, revoked and sent to prison for 2 theft cases. One was a TDC case, given 3 years, and so pretty much gets off parole barely and commits this offense, gets the opportunity at probation, and we're where we are now.
And he does have an extensive juvenile history. You will see a misdemeanor as well. And again, that's
Yes.
why I wanted to let the court know that an underlying probation offer was made with the issues with Miss Ibriana Bell that the court is obviously aware of by this point.
Okay, I am looking back at history, juvenile history, going back to 2013. Assaults, violation of court orders that look like it should have ended up in Texas Youth Commission. For some reason, they kept putting you on probation all the way until 2018, when you apparently become an adult. Then you start getting felonies and misdemeanors, get probations on all of those. Those are revoked. You beat the mother of your child while she's pregnant. You get a 5-year deferred probation, and you don't take advantage of that probation. I feel like at this time, what Ms. Lopez said is absolutely correct. You are a danger to your children. You're a danger to the menace to our county, and have been since 2013.
Just one thing. Do you know when his mental health was discovered? Or was it
Probably when he started using synthetic marijuana. So at this time, I'm going to find that you entered your plea of true. So you were previously in court, entered pleas of true to counts 2, 3, 4, 6, 7, 9, and 10. And then today, I am going to make a finding of true to counts 1 and 8 based on the testimony of Ms. Lopez. I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of aggravated assault with a deadly weapon. I'm going to sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And I'm going to hand you, and y'all need to sign this, trial court certification that shows this was not an agreement. There are some rights to appeal. You can talk to Mr. Burbank about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you. Hang on. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. You need to sign that, and then I'll get you a copy of it, and then you can go back with the bailiff. I do think that's fair, and hang on to, Mr. Bell, I can go up to 20 years today.
So, let's step back and look at the full picture. Brandon Bell stood before the court with a long history of violent conduct, drug abuse, probation violations, and chances that many defendants never receive. His final sentence, 12 years with an affirmative deadly weapon finding, reflects the court's determination that continued probation posed too much risk to his family and the community. We saw legal considerations, emotional testimony, and a judge who clearly wrestled with balancing rehabilitation and public safety. Drug use, mental health decline, and years of failed intervention all played a part in this final decision. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.